Ryan, and I'm here today to talk to you about my situation. I'm doing a lot of research on FinCEN, which is the Financial Crimes Enforcement Network of the U.S. Treasury, particularly as it refers to January 6th. And what happened to me. My name is Jenna Ryan, and I had a lot of things happen after January 6th, and I'm just interested to know how it all fits together. And so I was doing some research on the FinCEN website, and I went down here to the notices section, FinCEN bulletins and fact sheets. And I came down and I was looking for 2021, something that looked interesting. Then I found this one here. Okay. So this is the U.S. Treasury Financial Crimes Enforcement. We've got a eagle with a shield and a globe behind it. We have 010. I don't know what those mean. But that's what we have here. And this was in it looks like, what did it say? December 2020, which was the year of COVID, right before January 6th. So FinCEN previously issued this 314B, which this is an important number, 314 fact sheet on November 2016. This new fact sheet replaces the previous one. Okay. This 2012 has been rescinded, and here we are. What is 314B? Section 314B of the U.S. Patriot Act, which is the act that was put into place by President George Bush after 9/11. Section 314B of the U.S. Patriot Act provides financial institutions with the ability to share information with one another under a safe harbor that offers protections from liability in order to better identify and report activities that may involve money laundering or T activities. Participation in information sharing pursuant to 314B is voluntary, and FinCEN strongly encourages financial institutions to participate. Many of us who were involved with January 6th and targeted by the government and by all the businesses were labeled as T's, which I can't say that, just in case I put this on a platform where you can't say that. We were labeled as that regardless of our charges without due process. So this is the ability to share information according to the U.S. Patriot Act among financial institutions. And the front for this behavior talks about ML and T, okay? So that's why they're saying they're doing this. And then it says, what are the benefits of 314B voluntary information sharing? While information sharing pursuant to Section 314B is voluntary, it can help financial institutions enhance compliance with their AML, CT financing, AML CFT requirements. Okay, so there's another video we'll do where we talk about the AML CFT requirements, but that's not now because there's only so much you can talk about in one video. But this can help the financial institution enhance their compliance with this regulatory environment is basically what's going on. So this Treasury Department, the FinCEN, is regulating big time, and they are using this Patriot Act to delve into the personal information of people and label people according to whatever they want, it looks like. But we'll find out. What are the benefits of this voluntary information sharing? While information sharing pursuant to 314B is voluntary, it can help financial institutions enhance compliance with their anti-ML CFT financing. That should be CTF, huh? Requirements, most notably with respect to gathering additional information on customers or transactions potentially related to ML or T financing, including previously unknown accounts, activities, and or associated entities and individuals. So under this umbrella of the Patriot Act, they're requiring financial institutions to share information about any of this ML or T, CFT, ML, AML, CFT. But the problem is that they're calling it whatever they want. So it's not a true TF, CTF, CFT is what they're calling it. It's really not true. It's just whatever the heck they want, but we're going to get there. Including everybody they know. Pursuant to 31 CFR, FinCEN may modify or rescind any ruling made pursuant to its administrative authority. FinCEN has engaged in regular dialogue with financial institutions about the efficacy of 314B program and determined there is good cause to provide updated guidance to improve effectiveness of 314B program consistent with the statutory text and legislative intent. So this was in December of 2020. Remember, the 5th of December. Just kidding. So this was in December of 2020, and they were gearing up for something. What was it? We're going to find out. So Biden had been elected, and on January 6th of the following year, 2021, was when Biden was going to be put into office. And so they were getting ready for this, I guess. Shedding more light upon overall financial trails, especially if they are complex and appear to be layered amongst numerous financial institutions, entities, and jurisdictions. Building a more comprehensive and accurate picture of a customer's activities that may involve ML or TF is suspected, allowing for more precise decision-making in due diligence and transaction monitoring. Alerting other participating financial institutions to customers whose suspicious activities they may not have been previously aware. Facilitating the filing of more comprehensive SARs than would otherwise be filed in the absence of 314B information sharing. Identifying and aiding in the detection of ML and TF methods and schemes. Facilitating efficient SAR reporting decisions. For example, when a financial institution obtains a more complete picture of activity through the voluntary information sharing process and determines that no SAR is required for transactions that may have initially appeared suspicious. The problem is that the banks and the financial institutions are held very harshly to these standards. And if they do not do whatever these regulators want at FinCEN, or if they don't follow these AML laws, then they are fined millions and millions of dollars. And I personally ended up raising $200 in a Twitter fundraiser, and somebody thought I was, not worthy of that. So they booted me off publicly. So that's why I'm so interested in this. So who is eligible to participate in Section 314B information sharing? Financial institutions subject to AML program requirement under FinCEN regulations, and any association of such financial institutions are eligible to share. So they're saying you can voluntarily share information, but you don't have to. However, what they're not probably mentioning here is that the fines, if you don't do what they want you to do, are enormous and can destroy your company. They can literally destroy your company. So it's basically like, you better provide this information or else. Okay? Banks, casinos and card clubs, money services and businesses. So this is really like a tyrannical rule over banks, casinos, money service businesses, MSBs, which is broker or dealers in securities, mutual funds, insurance companies, future commission merchants, and introducing brokers in commodities. Dealers in precious metals, precious stones, or jewels. They want it all, baby. Operators of credit card systems, loan or financing companies, housing government-sponsored enterprises, associations consisting of financial institutions listed above. What information can be shared? Okay. Financial institutions. So notice how this started in 2012. What happened in 2011? I wonder. Financial institutions or associations of financial institutions may share information with each other regarding individuals, entities, organizations, and countries for purposes of identifying and, where appropriate, reporting activities that may involve possible T activity or ML. Information sharing among financial institutions is critical to identifying, reporting, and preventing crime. Sounds good, doesn't it? But we just have so much rampant stuff going on, and I don't know why they didn't go after. Anyway, specifically, financial institutions or an association of financial institutions sharing information under the safe harbor created by Section 314B may share information relating to activities that a financial institution or association suspects may involve possible T financing or ML. This may occur, for instance, when the financial institution or association is sharing information about specific transactions involving the proceeds of one or more specified unlawful activity, SUAs, as described in 18 U.S.C. 1956, which lists the predicate crimes that apply to ML offense. The SUAs listed in 18 U.S.C. include an array of fraudulent or criminal activities, including fraud against individuals, organizations, governments, computer fraud, abuse, and other crimes. However, to rely on Section 314B, Safe Harbor, a financial institution, which means you're not going to be held liable. Basically, they're saying, if you do these things, we will not come and charge you money in regulatory compliance. That's what they mean by safe harbor. So give us your information. If you do, you'll be safe from other regulatory bodies coming after you or something. I don't know. However, to rely on Section 314B, Safe Harbor, a financial institution or an association of a financial institution need not have specific information indicating that the activity in regards to which it proposes to share information directly relates to the proceeds of an SUA or transactions involving the proceeds of money, nor must a financial institution or association have reached a conclusive determination that the activity is suspicious. So they're saying, hey, you can just do whatever you want. You don't have to have, under these rules that we're making here in December 2020, you don't even have to have due process. You don't even have to know if that person is actually doing something bad. All the guardrails are off. All the wheels are off. You have no liability. You have no honorability. There's no constitution. There's no privacy. You have a right to do this, whether or not the person has done something wrong or not. You have the right. So basically, wheels off. We're giving you all free reign to give us everything we want and for you to do everything we want. You'll find later in my reporting. However, to rely on Section 314B safe harbor, which means to rely on safe harbor for who? Safe harbor for, not for the person. The person, if they're trying to say that this bank will not be liable to the person, that is false, because Congress can make no law that violates the U.S. Constitution. So if a private company does the will of the government and there is a direct nexus, then they're punishing people for what the government says they want you to punish them for, then that is a direct nexus. So there's not a safe harbor. This is a safe harbor that's not safe, based upon my understanding of case law and legal stuff. However, to rely on Section 314B, you can't rely on, I keep coming back to this, you can't rely on anything. They're lying. You can't, FinCEN, y'all need to correct your information. You can't rely on that unless they're talking about relying on the safe harbor from them coming and getting you for other things you've done wrong as a bank. A financial institution or association of a financial institution need not have specific information indicating that the activity in regards to which it proposes to share information directly relates to a SUA, which was a unlawful activity, or to transactions involving the proceeds of money, or financial institutions or associations have reached a conclusive determination that an activity is even suspicious. So the activity does not even have to be suspicious. And we do have a congressional report provided by Jim Jordan, Representative Jim Jordan in the House, and it was completed in December 2024, where he discussed the spying on Americans. And financial institutions spied on Americans, and this is, how they did it. And this is the rules that they went by, the guidelines. So instead, it is sufficient that the financial institution or association has reasonable basis to believe that the information shared relates to activities that may involve ML or TA, and it is shared the information for appropriate purposes under 3.1. So basically, Section 314B Safe Harbor is protecting the financial institution against liability with the government for sharing private information. Okay, so Section 314B gives the bank protection from being charged if the bank shares information. So I don't know who voted for this, but I'm going to find out. Okay, but there's a lot here. So instead, it's sufficient to know that Therefore, a financial institution or association can share information in reliance on Section 314B Safe Harbor relating to activities it suspects may involve ML or TA, even if the financial institution or association cannot identify specific proceeds of an SUA being held. So even if there's no money, they're given free permission to do this. Now, this doesn't mean that they're not liable if the end user finds out and is damaged and they find out, then that doesn't mean they have a safe harbor. But according to this document from December 2020, the financial institution will have a safe harbor with the government. So the government will not come back and charge them a whole lot of money for violating the privacy of people, because they're actually wanting them to share this information no matter what, even if they don't know what's going on. Even if there's no proof or no due process, they don't care. They just want to spy. Furthermore, a financial institution or an association of a financial institution may, in reliance on the Section 314 Safe Harbor, share information related to activities that may involve possible TA or ML, even if such activities do not constitute a transaction as defined in 31 CFR 10 blah, 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 or elsewhere. For example, a financial institution or association may share information on attempts to engage in transactions that the financial institution or association suspects may involve ML or TA. And the financial institution or association is sharing the information for an appropriate purpose under Section 314B. So basically, whenever PayPal leaked my information to the press, they leaked my SAR, which is, they had reason, under this safe harbor, they leaked it and thought that they would be safe because they're told to do so right here. Stop. That's my dog. Okay. I mean, I'm just putting things together. I don't have anything definite, but I'm just wondering. This is not definite. By the same reason, a financial institution or association may share information on attempts to induce others to engage in transactions such as a money, whatever that is, where the conditions of Section 314B are satisfied. Section 314B and its implementing regulations impose no limitations on the sharing of personal identifiable information under 314B safe harbor, where otherwise consistent with Section 314B and its implementing regulations. So as long as you're doing what we tell you to do, there's no limits on who you can share it with, what you can share, or how. Okay? No limits. Nor do Section 314B or its implementing regulations impose restrictions on the type of or medium of information that can be shared in reliance of Section 314B safe harbor, such as video surveillance footage or cyber-related data, such as IP addresses. Dang, who's surveilling? Section 314B information sharing can likewise be verbal as well as written. So you can talk about this person verbally, you can talk about this person in writing. Okay? Of course, financial institutions and associations of financial institutions must maintain adequate procedures to protect the security and confidentiality of all information shared pursuant to 314B and only use such information for purposes laid out in Section 314B and its implementing regulations. Did Kamala write this? Because that sounds like word salad. So you can do anything you want and share it with whomever you want as long as you're under 314B for whatever reason you want. But make sure you follow confidentiality and security. I mean, can you imagine being a financial institution? You're just trying to make money as, just trying to survive and, be profitable and be competitive in the marketplace. And here you are being strapped with this weird regulations. This is like, what? What are we supposed to do? In cases where a financial institution files a SAR, which is, I don't know the name. SAR, confidentiality standards. I don't know what a SAR is, but I know it's a write-up. Like if you think someone has done something wrong, it's a SAR. Where did that go? Anyway, Google it. It's SAR. Facilitating a SAR reporting. So I'm not going to go into SAR right here, but I just know it's a report, and I'll be going into that later. Okay? Where am I? Okay. You can do whatever you want. Just do whatever you want. Oh, God. Of course, financial institutions and associations of financial institutions must maintain adequate procedures to protect the security and confidentiality of all information shared. So technically, according to the FinCEN rule, you're supposed to keep it confidential. You're not supposed to leak it to the press. Okay? In cases where a financial institution files a SAR, so far, I mean, they'll probably add one in here. Leak it to the press if necessary. We'll find out. I'll find it if it's in here. In cases where a financial institution files a SAR that has benefited from Section 314B, your protection, your safe harbor, so we're not going to come and charge you for compliance problems. because you're so safe, because you're just doing what you're supposed to do, sharing people's info and digging into their business and sharing it with other people and video and da. Okay. FinCEN encourages financial institutions to note this in the narrative in order for FinCEN to identify and communicate specific examples of the benefits of the Section 314B program. Okay. In cases where a financial institution files a SAR, which is some kind of report, report that has benefited. If you file a report, file a SAR that's getting benefited by this 314B information sharing, FinCEN encourages financial institutions to note this in the narrative in order for FinCEN to identify and communicate specific examples of the benefits of the Section 314B program. So you've got to train your 4,000 goons who are spying on the American people and also communicating with the government and tracking the American people, and perhaps, all your AI. Can you stop? Just sit down. She gets excited when I'm talking. Okay, so anyway, in cases where a financial institution files a SAR that is benefited, you've got to write a little note. But yet our Treasury Department doesn't even write a note for money they spend. But if you're doing a FinCEN on an American citizen, which is totally and completely unconstitutional, especially, you can call anybody anything you want, and they end up calling dissent of the government, they call those people T's. So that's a problem. Okay, please note, however, that while information may be shared related to possible T financing or ML that resulted in or may result in the filing of a SAR, Section 314B does not authorize a participating financial institution to share a SAR itself or to disclose any information that would reveal the existence of the SAR. Wow. So you've got to train your staff to file a SAR with FinCEN. Okay. So the financial institution files a SAR. And if they don't file a SAR and you were supposed to file a SAR, I bet you get fined big time. But anyway, that's beside the point. And then it says, when you file a SAR, please note, however, that while information may be shared related to possible T financing or ML that resulted in or may result in the filing of a SAR, Section 314B, does not authorize a participating financial institution to share a SAR itself or reveal any information that you have a SAR. So you can file a SAR with the Treasury, with the FinCEN, with this law enforcement arm of the U.S. Treasury. You can file a SAR with them, but you're not authorized. You can file a SAR with them and share any information about anybody, whether it's true or not. Whether they have due process or not, and you can file it and they can become flagged as ML and T, no matter if you find out if it's true or not. Okay, you can file a SAR on a person. Okay, but you are not authorized. But you file the SAR with the. But where's the information sharing? Maybe I'm missing something. Let's see. Please note, however, that while information may be shared related to possible TF or ML that resulted in or may result in the filing of a SAR, Section 314B, does not authorize a participating financial institution to share a SAR itself or to disclose any information that would reveal the existence of a SAR. So you're not allowed to share a SAR. Please note, information may be shared. Information may be shared, but you may not say it's a SAR. You can't share the actual SAR. I want my SAR. Where's my SAR? I want my SAR. I want my SAR. I want some discovery. I want to see my SAR. Okay? I probably have more than one. They're like, everybody in the world's probably, oh, there she is. She's the blonde girl. Give her a SAR. Oh, no. She's a Trump supporter. Give her a SAR. Section 314B does not authorize participating financial institution to share a SAR itself or to disclose any information that would reveal the existence of a SAR. Okay, I just went into a Guardian knot that I don't know how to get out of. I feel like I am talking to Kamala, but this is even harder to understand. That's just like, okay, you can share all the information you want and you can share it among each other, but don't share the SAR. However, as discussed below, financial institutions sharing information pursuant to Section 314B may work together to file joint SARs. So you can file a joint SAR. Wow. So if one bank wants to join up with another bank, they can together file a SAR against a person. But they're not allowed to share their own individual SARs. Well, this isn't interesting. SAR confidentiality standards are governed by applicable SAR regulations. So I will be researching that in the next video. Okay. Can an entity that is not a financial institution under the BSA, I don't know what the BSA right now is, but look it up. I'm just now getting into all this. Sorry, y'all. Okay. And it's implementing regulations such as a compliance services provider, form and operate an association of financial institutions whose members can engage in information sharing covered by Section 314B Safe Harbor? Yes, of course. As long as you do what we want you to do. If you don't, we're going to fine you millions and make you look horrible in the media. We're going to say how horrible you are. We're going to say you're a terrible bank. You messed up really bad. And we're the government. And then we're going to skewer you and you're going to lose business. And then your shareholders are going to be ticked. That's what we're going to do to you if you do not do what we say and keep up with these strange rules. Okay? These tyrannical rules. Yes, FinCEN does not require the organization that forms and operates an association of financial institutions whose members engage in information sharing protected by the Section 314B Safe Harbor to itself be regulated financial institutions. You don't even have to be a regulated institution. Well, I don't believe... somebody needs to clean this up, okay? Furthermore, there is no Section 314B requirement that an entity forming and operating an association of financial institutions be a subsidiary, or corporate affiliate of a financial institution. So that means media, because I know somehow it's intricately linked, because what happened to me was the government, PayPal, media. Government, financial institution, media. Government, financial institution, Facebook. Government, financial institution, Instagram. Government, financial institution, Match.com. Government, financial institution, Zillow. Okay, so they're in this organization. Oh, CBS, NBC, the Washington Post, the New York Post, the Daily Beast, the Daily Mail. So they're all in something. And that's what this kind of points to. But I don't know that that's what this is. I'm just kind of guessing. I'm taking a stab at guessing. So any entity forming an association of financial institutions must, of course, form its activities with the other requirements of Section 314B, including the use and security requirements, which is 31 CFR, blah, 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 blah. Can an unincorporated association governed by a contract among the group of financial institutions that constitutes its members engage in information sharing covered by the Section 314B Safe Harbor? Ooh. Yes, Section 314B permits unincorporated associations to engage in information sharing pursuant. So anybody can just come and come after someone, and all they have to do is have someone decides. You don't even have to have suspicion. You don't have to have proof. You don't have to have any due process. So this is like life without a constitution. So this is like unconstitutional. We don't have a constitution. The individual, they're talking about individuals. I know that it sounds like they're talking about financial institutions, but these financial institutions are monitoring individual people, humans with hearts, with souls, with dreams, with hopes, with goals, with reputations, with work that, with life's work, with purpose, with beauty, with love, with families, with passions, with traumas, with faults. This is a human we're talking about, but nobody's talking about the human. There's no place here in this system for the feelings of a person. It doesn't matter. Your feelings don't matter. Your feelings don't matter at all to these people, okay, who are wielding this power to dig all into your business. Such unincorporated associations can exist you don't even have to be an incorporated association. So here we, as individuals, Americans, we have all these regulations and all this stuff, but hey, if they want to share all our information, we have to go through the TSA and they basically have to pat us down and touch our privates. But yet, these corporations that are in cahoots with the government here in spying on us, they don't have any kind of regulations, but they do. They have to pay. They have to pay compliance whenever they don't follow the rules. Okay? They have to pay. Interesting. Fleecing. All members of such unincorporated associations must be financial institutions consistent with the definition of the term 31 CFR 1 blah blah blah. Furthermore, an unincorporated association must operate in compliance with the other requirements of the Section 314B, including the use of security requirements. Jeez, thanks. Security requirements for whom? Probably for FinCEN, the Federal Treasury regulatory arm. Probably them. They're the probably only ones getting protected here. FinCEN regulate. Who is FinCEN all about? Are they for the public? Because they sure don't act like it. This does not seem like an organization that is advocating for public anything. They seem very much against the public. FinCEN Regulations 31 CFR 101 set forth the requirements that must be satisfied in order to benefit from 314B safe harbor protection, as outlined below. A financial institution or association of financial institutions will only benefit from the safe harbor protection if it follows the conditions for participation in the program, which means, I guarantee it's as arbitrary as this stinking Section 314B. It's going to be like, you better do what we say. You better hate who we hate. You better put on that t-shirt. You better put that on your website. You better plaster this on your walls. You better talk about this at your meetings. You better show this on your television programs. If not, we're going to come and fine you. Whatever the Treasury wants. The bureaucracy. Okay. And then they revoked something herein. Whatever. Submit a registration to FinCEN. Join today. It's voluntary. Submit a registration to FinCEN. Information regarding 314B registration process is available on FinCEN's website. And I'm not holding your arm behind your back. Financial institutions and associations that ever want to even dream of not being compliance filed, charged and billed, and if you want to be kept out of all future options of the Fed and all that, then you better do this. Financial institutions and associations interested in participating in the 314B program must first register with FinCEN's Secure Information Sharing System, SIS. So they have a system. They have a system for spying, for sharing all this. Interesting. Sis. The acronyms. I have a whole list of acronyms. It's like a whole new world. If they are not already a registered CIS user, upon logging into the CIS, users can then navigate to the 314B tab and submit a 314B registration. All registrations are processed within 2 business days of receipt, and participants will receive an acknowledgement via email. Well, thank you for that quick. Yet, if I get a FOIA request, it takes how many days? Why? Just kidding. Sharing information with other 314B participants. Prior to sharing information under Section 314B, financial institutions and associations must take reasonable steps, such as checking the FinCEN 314B participation list to verify that the other financial institution or association is also a 314B registrant. So that's how they make everybody get involved. To facilitate the identification of 314B program participants. So, interesting. Very interesting. CIS provides tools to search the 314B participant list for other participants or download the participant list in its entirety. No wonder PayPal has to have 4,000 people just to handle compliance. God. FinCEN updates updates the list in real time. Financial institutions and associations may establish policies and procedures that designate more than one person with the authority to participate in the financial institution 314B program. So you can designate more than one person to go in there. What? So all your information goes in there? To facilitate the identification. Okay, FinCEN updates the list in real time. So this is just the list of financial institutions. They update it in real time. Financial institutions and associations may establish policies and procedures that designate more than one person with the authority to participate in the financial institution 314B program. Safeguard shared information and use only for AML CFT purposes. Financial institutions and associations must establish and maintain procedures to safeguard the security and confidentiality of shared information and must only use shared information for the okay, can we stop? They are calling our details of our lives that they are getting in digital form, that they're getting from our phones. This is saying video, surveillance, this is saying whatever, this personal information, this private information of an individual person with constitutional rights from the U.S. Constitution. First Amendment rights, freedom of speech. We have the Fourth Amendment right, freedom from unlawful search and seizure. I think that's which one that is. This is just violating so many rights. They're just smashing rights. They don't give a crap. They're calling you and your private data personal information. If they even think that you've done something that they don't like. Now, that might mean you voted for Trump. That might mean you voted for Trump, but you never, talk about it publicly. Or maybe they saw you in a bank wearing a Trump shirt. They can write a SAR on you. I'm not saying that that's how bad it got, but would it get there? Yes, absolutely, if you let these tyrants run crazy. Okay, financial institutions and associations must establish and maintain procedures to safeguard the security and confidentiality of shared information. And really, it's really confidentiality to protect their butts. Anyway, and must only use shared information for the purpose of identifying, where appropriate, reporting on activities that may involve terrorist financing or ML, determining whether to establish or maintain an account or to engage in a determining whether to establish or maintain an account or engage in a transaction. So when Bank of Texas dropped me, They were probably involved in this 314B, and there was a SAR written about me somewhere from years ago. And they took that SAR and determined to. Oh, also, I was donating to the J6 political prisoners. I was donating. I was regularly donating to a J6 fundraiser to help the J6 people get out, or, to pay their commissary or their bill, their light bill. And then I was booted from Bank of Texas. So they didn't like that. It's because it's not allowed. I have a problem with that. Assisting in compliance with anti-ML requirements. May financial institutions that share information pursuant to Section 314B file joint SARs? So I guess Bank of Texas thought, well, we really like Jenna. She hasn't done anything wrong. But if we do not boot her, we could potentially be fined thousands and thousands of dollars. Millions, maybe. If someone came around and said, why are you banking with Jenna Ryan? We don't like her. Boom, we're going to violate you. We're going to give you a violation and put it all over the news. So they can't afford to associate with a targeted person. Wow. So it's not, somebody's got to bring this forward. May financial institutions that share information pursuant to a Section 314B file joint SARs? FinCEN, which I just think of FinCEN as the devil. FinCEN is not my friend. FinCEN is nobody's friend. FinCEN is there to hurt us as beautiful people in America. They want to take away your rights and violate you and control you. FinCEN SAR regulations allow for the submission of joint SARs by financial institutions. When financial institutions identify suspicious activity through collaboration pursuant to Section 314B, they may consider whether a joint SAR would be the most efficient way to provide highly useful information to law enforcement. However, we have how much going on of all this, CT? We have so many bad things going on. And they're going to come after J6 people, but they don't come after the Minnesota Freedom Fund. Anyway, financial institutions should keep in mind that Section 314B does not relax the prohibition against SAR disclosures. So there is a prohibition. We're going to talk about that soon. Prohibition against SAR disclosures, nor does it otherwise address SAR confidentiality. Financial institutions participating in information sharing pursuant to Section 314B remain prohibited from disclosing a SAR or any information that would reveal the existence of a SAR, notwithstanding 314B. However, financial institutions participating in Section 314B that are considering filing or have filed a joint SAR may freely discuss the prospective or already filed joint SAR amongst themselves. So they can talk about you. They can talk about you with their mouths. They can discuss via email, Zoom calls. They can Zoom and discuss individuals. Oh, Dawn and Sue. He's a bad one. That Dawn. Sue, oh yeah. She was wearing a Trump shirt. She wore the Trump shirt to the bank. I saw that. Give her a SAR. But don't tell anybody. Don't tell anybody you have a SAR. It's private. It's confidential. You might get compliance fees. You're prohibited from telling anybody there's a SAR. So you're prohibited from sharing about the SAR. But you are encouraged to communicate and talk about this SAR. Which is it? Who made these rules? This is why we need a U.S. Constitution, because how do you keep these rules straight? And also, how do you keep from smashing on people? I think I should call this person and say, hey, question for you. Changes, updates, or deletions of current 314B registration information can be made through the SIS. Sounds like a snake. Spies. A detailed 314B user guide is also available in SIS. For additional questions, do this, that, and the other. There you have it, folks. It is everything you ever wanted to know about 2020. How do I make this go bigger? 2020 Financial Crimes Enforcement Network. Thanks, FinCEN.